When did you form a belief in your own mind that a rape had occurred?
Probably on the 27th of March.
And what did you have before you that caused you to form that belief?
The opinions of two officers and through them the opinion of the same nurse, all of which was confirmed subsequently, but I believe that I had accepted it at that time.
And is it fair to say that up until the time you dismissed the rape charges, you personally believed that a rape had occurred?
Yes, sir, I think that's fair.
And even after you dismissed the rape charges, you personally believed that a sexual assault had occurred, even if it had not been rape?
Yes, sir, I think that's also fair.
Did there come a time that your belief that a sexual assault occurred changed?
I am aware of the report and have read the report from the Attorney General's office. I had conversations with Mary Winstead and Jim Coleman during the course of that investigation. I understood their reasons for saying that there was not sufficient evidence to go forward, not sufficient credible evidence to go forward in the case, and based on my knowledge of what they told me, believe that to be the case. I have not seen all the evidence that they have seen in terms of when they made their conclusion that this was a case of actual innocence, but I don't have any specific reason to question that conclusion at this time. In other words, there's not something that I can say that I disagree with them on. I just don't have sufficient evidence to know at this point anything different from what they've said.
As you sit here today, do you have a personal belief as to whether or not a sexual assault occurred?
At this point, I think what I would have to say honestly is, I think something happened in that bathroom, but I'm not sure that I can say that I now at this point believe it was a sexual assault.
If not a sexual assault, then what?
A non-sexual assault, a intimidation, something happened to make everybody leave that scene very quickly.
Okay. I want to ask you a few questions about your early statements. I believe you said you started making the statements at issue here on March 27th. Is that correct?
That is correct.
And at the time you made those statements, were you aware of any restrictions, ethical or otherwise, on your ability to speak with the press about this case?
I would say, generally familiar with the provisions of 3.6 and 3.8. I probably would have been well served to make myself a little bit more specifically familiar with some of those provisions.
Did you actually look at Rule 3.6 and or Rule 3.8 at any time before you stopped making those statements?
At any time before I stopped making those
Before
statements?
you stopped making the statements.
I believe that I probably looked at the rule at about the same time that I stopped making the statements.
About the same time?
Yeah, yes, sir. I think that I may have looked at the rule because of my concern that I needed to stop.
What had provoked that concern?
Pardon?
What had provoked your concern that you might need to stop?
I had some non-lawyer friends who were suggesting to me that that they thought that I was talking too much. And so I considered that perhaps I had been, and that while I was thinking about these situations, I might want to look at the
Now,
provisions.
you had received by fax on March 30 from Mr. Cheshire's office, Exhibit 205, where he basically asked you to do exactly that, didn't he?
Yes, sir, and that particular week was a very busy week, quite possibly the busiest week of my life. I don't know when I first saw that letter from Mr. Cheshire. It may have been March 31st, the following day. There's a that would have been the earliest I would have seen it. It's also possible that I did not see it until the following Monday, or to actually have a chance to read it until the following Monday. That was about the time that I stopped making these statements. My recollection is that I had decided not to make any more statements by the time that I read Mr. Cheshire's letter, but I'd made that decision pretty much on the 31st, other than the interviews I'd still already agreed to do.
And again, that was after you had received advice from friends, non-lawyer friends, that you ought to stop talking so much.
Well, there were some people that thought that I was talking too much. They weren't specifically accusing me of ethical violations, but they thought that I was maybe saying too much about the case. It's also getting very clear by this time that whatever the intent of the statements were, they weren't having any effect. Nobody was coming forward to talk, apparently, as a result of the statements. So the efficacy of making statements was becoming, quite problematic in and of itself.
So they weren't working.
No, sir, they clearly did not work.
Did you, in making the decision to stop making these statements, include in your decision-making process an ethical concern?
I don't know that I did. I attempted to make the statements in an ethical manner. I think that I failed to do that in some situations, and part of that had to do with my misunderstanding of the situation, of some of the specifics of the rules, perhaps. But the decision to stop, I don't think was so much because I thought that I was committing or continuing to commit an ethical violation, so much as I think that I realized that all the consequences, all the potential consequences of my statement might not have been apprehended by me initially.
Do you have in your office a copy of the State Bar Lawyer's Handbook?
Yes, sir. I do have several years worth of that.
At any time during your handling of the dupla cross cases, did you refer to the ethical rules in that handbook for any purpose?
I believe that I did, but it was sometime after this March-April period.
What do you recall about that?
I recall looking at specifically Rule 3.8, the duties of the prosecutor, and also the exceptions in Rule 3.6 with respect to the kinds of things that I was allowed to say.